Good morning, everyone, and welcome to another seminar presented by Greens List. This morning's topic is on Personal Property Security Act, otherwise known as PPSA. The PPSA came into effect on the 30th of January 2012. It establishes a priority registration regime of security interests in personal property. The regime brings Australia in line with similar regimes operating in New Zealand, Canada and the United States. There has been some recent media criticism surrounding the new PPSA register. That feeds into the perception that the PPSA is a complex and unwieldy piece of legislation. However, overseas experience suggests that lawyers will quickly adapt to the new regime. Shortly after a similar act was introduced in New Zealand, two commentators had this to say: "The PPSA is a complicated, provocative and fascinating scramble of legislation. Although it initially overwhelms many lawyers, the deeper one explores its secrets, the more one appreciates how innovative it is. Once the unfamiliar concepts and strangeness wear off, it is apparent that it is a well-knit piece of legislation, though not without its faults, that provides uniform rules that, in comparison to pre-PPS law, operate and provide answers consistently and predictably. It will be interesting to see how this legislation is perceived in Australia once the dust settles." The principal focus today of Mr. Adrian Muller's seminar is to provide a general overview of the new regime. Adrian is a commercial barrister with Michael Greens List. Before coming to the bar, Adrian was a senior associate in dispute resolution group at Baker & McKenzie. He has experience in advising and acting for Australian and international clients in a range of complex commercial and corporations matters, including shareholder claims, directors' duties, corporate compliance, schemes of arrangement and insolvency matters. Adrian is also experienced in alternative dispute resolution processes, including negotiations, mediations and arbitrations. He has advised on and acted for a range of clients in contractual disputes, trade practices issues, professional negligence and other torts. Adrian has also advised and represented corporations and individuals in Australian securities and investments examinations and investigations. Amongst the highlights of his career include submissions made before the Takeover Panel, involvement in a large shareholders oppression action, and acting for clients whose assets were frozen under the Proceeds of Crimes Act. Adrian is a very experienced and general commercial barrister, and I'm sure that you'll enjoy his presentation.
Thank you, Caroline. Good morning, ladies and gentlemen. I need to update my career highlights, obviously, because I've left out the 50-odd runs I scored in a semi-final back in the 1990s. Let me introduce the PPSA to you by saying this. A lot of what we all know and learnt about personal property security we need to take and put to one side, and we need to think about this act as the same sort of reform that the Torrens Titles reform brought to land law. So in the same way that before the Torrens Title reforms came in, land law was governed by a mixture of the development of common law and bits and pieces of legislation here and there, and you had very complex mixtures of legal and equitable rights, and trying to work out priorities in all of that was all very difficult. And the Torrens Title reforms, to a large extent, swept all of that away and said, That was the old, this is the new. The PPSA does a very similar thing both in concept and in practice to what the Torrens title system does for our land law. It covers security interests in personal property. And what I want to do today is to break that down and give you an explanation and a roadmap through the way that the Act works and the way the regime works, so that you have, by the end of it, I hope, the building blocks that you can understand how the Act is meant to operate and the key concepts that arise out of the Act. So the first thing to note in that is that it creates a set of priorities for the determination of security interests. That's the very first thing it does, and it does that in order to give what the Act and the explanatory memorandum say is greater certainty to people in the marketplace about when they enter into transactions, so that they can understand what their risks are and they can price risk appropriately. The essential building blocks of creating those set of priority rules are having a security interest, the attachment of the security interest, and perfection of the security interest. You'll see from that already that there's a new language that's being brought around this Act, and as we go through the presentation, I hope you'll understand what those words start to mean. So the first question is, well, what is a security interest? And it's an interest in personal property that arises from a transaction that secures the payment of debt or performance of obligation. That is, in just good old-fashioned language, it's where you've got some sort of loan agreement and some asset is put up as security or collateral, as the Act calls it, for the giving of the loan. It also includes, in various situations, what are called deemed security interests, which are various interests that are defined under the PPSA. For example, a lease or a bailment of goods for more than 1 year or over an indefinite term will constitute a deemed security interest for the purpose of the Act. So when you're looking at whether particular classes of loan, security, hire purchases, chattel mortgages fall within the definitions of the Act, you have to look firstly at whether it in itself gives rise to a security interest, or then whether it gives rise to being a deemed security interest under the Act. I've set out for you what is personal property. Again, if you start from the position that if it's not land, then you need to think about it in terms of personal property, and if it's not fixed to land, then you need to think about it in terms of personal property and work back from there. And the Act has a number of inclusions and a number of exclusions, which you'll find as you go through the Act. But for example, things like some water rights or gaming licences are excluded by operation of the Act. The next thing that we turn to is the security interest has to attach. And what do we mean by that? Well, there has to be, the security interest must have some form of collateral for that security interest to be enforceable against the grantor, the person who's received the loan and given the asset as security. And that's very similar in concept to the creation of legally binding arrangements or agreements or contracts. And the Act says that a security interest attaches to collateral if the grantor has rights in the collateral and accepts value for the security, or does some other act by which the security interest arises. I won't give you details of what some other act means, but again, if you think about it in terms of the two scenarios. One is that when you go to a bank and ask for a loan, the bank will say to you, well, what security are you going to give me? And you say, well, I've got my house, and the bank says, thank you very much, we'll take that in return for giving you the loan. Your house then becomes the collateral, and that has attached in order to the loan, and then you have the security interest that's attached, and you've got the situation that arises. The second way that it can arise, of course, is I can sell you a box of pens and you agree to pay me half now and half in 3 months' time. So you receive the pens, you pay me half, but there's a promise to pay the other half in 3 months' time. Again, the pens are the collateral that attach to that promise to pay the remainder of the outstanding amount in 3 months' time. The next step, and perhaps the most important step, because this is where the Act starts to move away from what we understand as the traditional position into the new regime, is once you have a security interest and once you have attachment, then in order to preserve the security interest, particularly in insolvency, and also in order to obtain the benefits of the priority regime that the Act provides for, then the security interest, the attachment, the security interest need to be perfected. And perfection is a technical concept that's particular to the PPSA, and it's the way that it goes about is that you have to either have possession of the collateral that's been put up for the security interest, and that will give you perfection. So the house situation won't obviously won't work there, but I might go to you and say I want to borrow $10,000 and I'll give you my mother's engagement ring as collateral for that. If you take possession of the engagement ring and give me the $10,000, then taking possession of the collateral perfects the security interest, and all of the enforcement or the priority rules come into play. That's the unusual way that it happens. The more usual way that you'll perfect a security interest is by registering it on the register. And once you have done that, then you have the benefit of various priority rules, and perhaps much more importantly, if you don't do that, or if your client doesn't do that, then in the event of insolvency, you don't just lose your priority as against someone else who might have a security interest in that collateral. You also lose your status as a secured creditor. So in the event of an insolvency situation with a company or a bankruptcy with a person, if you have an unperfected security, so it's not registered or you don't have possession of it, then you lose the priority that you had as a secured creditor. You can still prove for your debt in the general winding up or the bankruptcy, but you don't do that from a secured position. So that's a radical change to how the Act operates, and you can see for us as lawyers, it's a point that is of particular interest in terms of our exposure when clients ask us to be involved in the registration of security interests under the PPSA, that if that final step is not gone through, if it's not perfected, then the clients are at real risk of being in a much worse situation than they thought they would be, and actually could have been if the security interest had been perfected. So I've set out there for you on the slide what those consequences are so that you can look at them later. To delve a bit more into the detail of it, under the way the register operates, a financing statement has to be prepared which sets out the details of the transaction, and then that is lodged with the registrar who puts it on the register, and at that point other people are able to search the register to see what security interests attach, either by company, by person, or in particular asset classes by serial number. And those asset classes are for things like motor vehicles, aircraft, I think some boats and ships, and a series of other things which again are set out in the Act. But using motor vehicles as an example, when you go to perfect the security interest in a motor vehicle, the Act says you have to do that using the serial number that is unique to that particular motor vehicle. And so when the registration process goes through, you register using the serial number, and then if a person wishes to buy that same motor vehicle and conducts a search of the register within a particular time period, it's 24 to 48 hours, I think, from memory, before they complete the transaction, if the register doesn't show any security interest attached to that motor vehicle on that serial number, then they take the motor vehicle free of any previous encumbrance. Critically, that means that if you get the serial number wrong and someone searches by serial number, they won't find that asset, and that's your fault, not theirs, whoever put the serial number up. So again, that's got quite dramatic potential consequences for clients who are in the business of providing security and taking collateral, providing loans and taking security over collateral which is serial number registered and required under the Act. So again, people have to be very careful how they go about that process and make sure they get the serial numbers right, because the consequences are, as I said, significant. Turning to the priority rules and what they actually are, again, a lot of this will make sense to you. It mirrors what happens in the Torrens system for land, and but it does, similar to the Torrens system of legal and equitable rights, the legal rights which arise with compliance of the Act almost inevitably trump any equitable rights that a person might have in the collateral. So a perfected security interest takes priority over an unperfected security interest, even if that perfected security interest is created later in time. Priority between two or more perfected security interests is determined in favour of an earlier perfected security interest over a later one. That, I think, makes perfect sense to nearly all of us. And priority between two or more unperfected security interests is determined in favour of an earlier attached security over a later one. So you can see once you start to get down to that third bullet point, then you're in an area where there's a lot more scope for argument and disagreement and trying to work out what dates security, collateral attached to security, and what came first and what came second. That's much more complex. And then remember also, when you're dealing with unperfected securities, if it's in a liquidation, well, you've lost your secured creditor status in any event. That's the default position. There are a number of specific priority rules that apply throughout the PPSA, and I'm going to talk about one in particular, which is what's called purchase money security rules. So let me go back to my pen example. So I agree to sell you a box of pens, and you agree to pay half now and half in 3 months' time. I then go and I register that as under the PPSA on the register, and it's perfected. So I have a security interest with the collateral attached, and I've perfected it. I'm feeling pretty comfortable at that point in time, until it dawns on me that sometime prior to me doing all of that, the bank has taken what we would have called in the old language a fixed and floating charge over all the assets of the company, and they have, which is now called a circulating charge. They take and they have gone through exactly the same process that I have. They've advanced money, they've taken the collateral being all of the assets of the company, past and present, fixed and floating, and they've registered that on the register, so they've perfected that. So they have a priority over me because they're first in time. So now I don't feel so good about my box of pens and my exposure to what happens when the company becomes insolvent, and I start to scramble around to think, well, what could I have done different? What I could have done different is I could have used what's called a super priority and registered a purchase money security interest. And it arises in specific situations. Most commonly for most of our clients, it's going to arise in situations where there's been what in the past would have been a retention of title clause in the agreement. So under the old regime, when I provided the box of pens, on the back of my invoice I would have had that lengthy retention of title set out that said this is we've created a trust situation and you hold the pens on trust for me, and I'm entitled, if you don't pay me, to trace the proceeds of those pens through. And then when the company goes into insolvency, the liquidator takes hold of all the assets and the remaining pens, and I come along and say, no, I've got this retention of title and you hold those pens on trust for me, and it's a mess for everyone. What the Act allows me to do now, rather than go through that whole process, is prior to providing the pens to the supplier, the customer, I register my purchase money security interest in those pens. That is to say, I register that the only reason those pens are being provided is because there's a promise to pay back for those, and if it weren't for the operation of the Act, then I would have been using a retention of title clause. The Act says in those circumstances where you register that interest before you supply the box of pens so that the world at large knows what's going on, then in the event of an insolvency, which is where this will arise, I have a super priority in relation to that box of pens, or the money advance for that box of pens, over all of the other creditors of the company. And you might say, well, that's terrific, but you supply boxes of pens every week to this company. Well, what do I do about that? Well, you can register a single registration for ongoing supply, and you get the benefit of the super priority from the point of registration of that ongoing supply on. So if I've been supplying boxes of pens for 6 months and 3 months into it, I realise that really I need to have this purchase money security interest registered. And at that point I go through the process of registration. Then I would have half of my my boxes of pens would be subject to a super priority for payment in the event of insolvency, being the ones that were created or supplied after that interest was created, and the former, the ones before, would have an ordinary priority. That would mean they would sit behind the bank's fixed and floating charge. One of the benefits that gives you is that all of the tracing obligations which we tried to import through retention of title clauses in setting up trusts, and as if you remember, tracing is an equitable remedy that only arises where you can invoke the equitable jurisdiction, is set to one side because the Act allows that proceeds are traceable whether or not there's a fiduciary relationship between a person who has a security interest in the proceeds and the person who has a right or has dealt with the proceeds. So what it allows is that if you have not the box of pens so much, but maybe legs for a chair that you supplied under a purchase money security interest, and those legs get put on the chairs and the chairs get sold, but you still haven't been paid at the moment of insolvency, then you have an ability to trace through to the proceeds of the sale of those chairs in order to extract your share of the payment for the legs of the chairs. The Act also allows you, in that same situation where you're supplying legs for a chair that get mixed into the final product, to maintain your security interest without losing. You don't lose your security interest, I should say, when the goods are installed or affixed to other goods, unless they are both serial numbered property, and that's they're the sorts of situations where you might have an aircraft that is a serial numbered piece of property and also an aircraft engine that is a serial numbered piece of property, and specific rules apply for that. But in the general run of things, just because the goods that you have supplied with a retention of title or a PMSI have been mixed into other goods doesn't negate your right to enforce your security interest in them. So examples where that might happen are the owner of a truck has has given the truck as security interest to the financier who purchased the truck, and then I supply a crane to the owner of the truck, and again I take that crane as, well, I take a purchase money security interest over that crane because I'm being paid on terms. When the truck owner then attaches or affixes the crane to the truck, under the old laws of personal property, you'd have a situation there where the goods have been combined and fixed, and there's a question then now about, do you have a truck with a crane attached to it, or do you have a truck and a crane that's become a new piece of equipment? And particularly then if that truck and crane is sold off to a third party as a complete unit, it's very difficult to work out who has what rights. Under the Act, the crane remains as an accession to the truck, and having taken my security interest over the crane, I'm entitled to either enforce that through, keep my security interest and ultimately affect my payment, and if the truck's been sold to a third party, to trace that through again, and out of the proceeds of the sale of that truck get paid for my crane. So turning to what is the last linchpin of the way the Act operates is the PPS Register, and no doubt you've been picking up in the media reports that the register, which went live on the 1st of February, has had significant teething problems. We'll talk about that a little bit more, but let me tell you what it is first. The idea of the register is that it's an online register of security interests. And it means that people can, on payment of the appropriate fee, go online and search to see what interest is, what collateral has been provided as security interests are for various companies, individuals, or look for serial number property to see whether it's been given as collateral for security interests. The registration process is to go through the application on an approved form, which includes a financing statement, which can and in most cases should be separate from the actual agreement. So you as solicitors will go through the process of documenting the agreement between your client and the customer in the ordinary course, and you'll have some sort of loan agreement that will pick up the terms and conditions of the loan. Some key elements of that need to be extracted out into the financing statement, most pertinently to identify the collateral that is being given as security for that loan. And then that financing statement, or some of the information from that, will be accessible on the register. So if you just go through the process of including the financing statement in the actual loan, then commercial and confident information or private information might end up on the register being accessible. So that's why I say almost always you should separate the two out and have a separate financing statement. And then all of that is sent through to the registrar, and once it's been put up on the register, then the verification statement will be sent out to the secured party, and that can be relied on to prove registration. So again, as a practice point for those of you who are doing this and advising clients on it, you can't be confident that you've gone through the whole process and your security interest has been perfected until you get that verification statement back saying that this has happened. In the event that the register gets it wrong, or in the event that there's been the parties have got it wrong, or they've misdescribed the security, or they've got the whole thing completely wrong, then a demand can be made by the grantor to the secured party to amend the register. If that doesn't happen, then within 5 days, then the giver of the demand can apply to the registrar, who must amend or remove registration in accordance with the demand. And then if the secured party disagrees, they can seek a court order to restore the registration. So it's a process that you go through where if your asset appears on the register as being collateral for a security agreement, and that's not right, or it's passed and it should be removed, then the first thing you do is give notice to the security interest holder. If they don't comply, then on notice to the registrar must remove it, and then the security interest holder would have to go to court to have the registrar amend the register. We'll take a break now.